We've talked a lot about how the Second Amendment's interpretations goes along the lines of text first and then history second. I want to modify that just so we're very clear going forward, and you'll see why what I'm about to say is so important to protecting our rights. The new test, as I see it, should be text first and historical analog laws second. Stay tuned. Let's get geeky. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty and Frederick Douglass. Okay, folks. In the Supreme Court case of Nysurpa versus Bruen, the Supreme Court did several things, and we've talked about it before. One of the things, of course, it did is reaffirmed Heller's in common use test when you're dealing with a gun ban case. But I don't want to talk about gun ban cases today. I want to talk about the historical analog part of the Bruen case, dealing with regulations of firearms and other gun-related laws other than gun ban cases, which again is governed by Heller and the in common use test. In Bruen, the Supreme Court made it extremely clear how to do the analysis, and it's very simple. You look at the plain text of the Second Amendment, the words of the Second Amendment, as then interpreted and defined by the Supreme Court in Heller and Bruen. It lays out all the words. Arms are anything that can be used offensively or defensively. To keep means to have or possess. To bear means to carry in public. No problem. All these things are nicely defined by the Supreme Court if you just read it. And of course, things that are necessary or help facilitate those rights obviously are also protected. But let's carry on. I don't want to talk about the plain text of the Second Amendment today. What I want to talk about is that next step. Once the plain text is implicated by or touches fingers with a modern-day gun control law, which means if a modern-day gun control law somehow infringes upon, restricts, discusses, addresses the right of the people to keep and bear arms, then that gun law is presumptively unconstitutional. Unconstitutional. In the same way that when we go into a criminal court, we are presumed to be innocent. In contrast, when it comes to a modern-day gun control law, that modern-day gun control law is presumed to be guilty. That modern-day gun control law passed by the government is presumed to be unconstitutional. And the burden of proof lies with the government to overcome that presumption that the law that they enacted that infringes or touches fingers with the right of the people to keep and bear arms is somehow constitutional. The burden is on the government to show that. So the question is, how do they do that? Well, the Supreme Court made it very clear how it works. The answer is, and then I'm going to flag for you the danger that we have to watch out for, because the anti-gunners are slick and they're smart and they have ways to try to weasel their way around stuff to try to win. But don't worry, folks, because I'm on the case, and other people like me, I suspect, are also on the case, watching out for how the anti-gunners are trying to dupe America's courts, and it's not going to work. So, how are the anti-gunners trying to play the game, and what did the court say? Well, what the Supreme Court said twice, I repeat, not just once, but twice, is that the relevant history is not history generally. It's not like a History 101 class in college. It's not like an American history course in high school. No, there's a specific kind of history, specifically the historical tradition of firearm regulations. And that word regulations is hugely important because that's talking about existing enforceable laws. Let me show you. In Nysurpa versus Bruen, this is specifically what the Supreme Court wrote. Quote, "In keeping with Heller, we hold," that's a very important word. The word hold means it's the central conclusion of the court, the main conclusion of that opinion. The court writes, "In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation," which is gun control law, to justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulations. You see what I just said there? The nation's historical tradition of firearm regulations. This is not my language. This is the Supreme Court's language of what courts must do. Now, this is what's so very important. The words, I want to break it down. Historical tradition of firearm regulation. Historical tradition. The way this works is really simple. That the government or the anti-gunners have a duty, if they want to justify their unconstitutional, presumptively unconstitutional modern-day gun control laws, they have to canvass, they have to look at history. And but they're not just looking for history, for stories, for cute anecdotes, for some sort of trend lines. No. They're looking at history for a very specific need, in our context, those very specific needles in the haystack. What I mean by that is they have to find, at the time of our founding, a particular type of history, a historical tradition of firearms regulations. Now, this is very important because the word regulation has a particular meaning in this context. It's talking about laws. It's talking about actual laws that are enforceable in court, for example. Those could be county laws. They could be city laws. They could be state laws. They could be government laws. They could be federal government laws. It doesn't matter. They have to be some sort of law in place, not generic history, but laws. Again, the modern-day gun control law has to be consistent with this nation's historical tradition of firearms laws, is what they're saying. Okay? And you're going to see why this is so important, because the anti-gunners are trying to play games here, but we've caught them, and I think we've nipped it in the bud. And you'll see just how right I am with a very great decision we just got last week on this very point. But remember, the Supreme Court really used Bruen. To keep this in mind, Heller talked about text, history, and tradition. Bruen reaffirmed that, but what Bruen really did is they said to the lower courts, under Article 3 of the U.S. Constitution, the inferior courts, they made it very clear to the lower courts, stop messing this up. Stop doing interest balancing tests under the notion of tiers of scrutiny and do what we say. Specifically, go out there and use text and history, specifically historical analog laws at the time of the founding to figure out whether or not the Second Amendment has been violated. Let me tell you why it's so important that the Supreme Court's Bruen decision is really a reaffirmation of Heller and the tests set forth in Heller. Except what Bruen did is it spanked the lower courts that were misbehaving. And that's how to view Bruen. Yes, Bruen says that the right to bear arms means the right to carry guns outside the home. That's a major part of its conclusion. But really a big part of what they were trying to do in that decision is to say to the lower courts that were engaged in just rank disobedience of the Supreme Court's decisions in Heller and McDonald and Catano, and basically the Supreme Court spanked them and says no more. We're actually going to not just give you the holding once, which I just read to you a minute ago, we're going to do it twice. This is the second time, this is the second thing that the Supreme Court in Bruen said. They repeat themselves a second time in Bruen. Here's what they write. Quote, "We reiterate that the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation." Again, regulations, not just airy-fairy history, but actually nation's historical tradition of firearms regulation. Only then may a court conclude that the individual's conduct falls outside of the Second Amendment's unqualified command, period, close quote. So the Supreme Court could not have been clearer that what you have to find if you want to justify an existing gun control law is a historical tradition of firearms regulations, which are actual laws. And you may be saying to me right now, Mark, why are you hammering this home? Why are you forcing us to understand that at the time of our founding, this is all about the anti-gunners have to find laws on the books that were enforceable? It seems so obvious. Yes, it does. But I'm emphasizing this because one of the little slick things that the anti-gun movement and the gunner and the anti-gun movement and the government entities that are trying to justify gun control laws are trying to play games with is they're trying to get courts to ignore the two holdings of Bruen that I just read to you and try to get them to look at general history, stories, trends, as opposed to specifically what the Supreme Court says you must do, which is to find historical laws that are enforceable on the books. And why do the anti-gunners want to go and do this? We know why. Because at the time of our founding, at all relevant periods, there really are very few gun laws or gun control laws in American life. Obviously, an obvious one that we can all agree would not violate the Second Amendment's right to keep and bear arms are laws going all the way back to even before our country was a country that says that you cannot use firearms or misuse firearms to commit a murder, to commit a rape, to commit a robbery. You're not allowed to misuse firearms. The Second Amendment's right of the people to keep and bear arms protects that right, but it doesn't allow you to commit murder and all these violent crimes. We know that because those laws against that kind of activity with firearms were on the books going back all the way before our country was a country through today. That is the kind of example of the nation's historical tradition of firearms regulation. Those types of laws banning the misuse of firearms have been on the book since, again, before we were a country. That does not violate the Second Amendment. This is the sort of thing the Supreme Court is telling the government to go find. And if the government cannot find such a long-standing tradition of those kinds of laws, the government loses. And we, as Americans, win, as well we should, because we have a Second Amendment right that's fundamental, on par with all the other rights, including the First Amendment's right to free speech, for example, a right to keep and bear arms. So, of course, we should win. When in doubt, the tie goes to the American, a tie goes to the citizen. That's exactly what the Supreme Court said. And again, when in doubt, throw it out. I repeat, that's my saying, but you can use it. When in doubt, throw it out is how courts should be applying the Second Amendment. When in doubt, throw out the gun control law. When in doubt, throw it out. Take it with me, use it, put it on Twitter. I leave it up to you. It's about winning as far as I'm concerned. I don't need the credit. Now, you're probably asking me, Mark, give me an example of where the gun control movement or the gun control advocates are doing what you say they're doing, which is to try to get around the clear holdings of NYSERPA versus Bruen as a way to justify more gun control laws. Well, I'm going to do that right here and right now. In the District Court of Minnesota case of Worth versus Harrington, which was a case brought by the Firearms Policy Coalition and the Second Amendment Foundation dealing with 18 to 20-year-olds in the state of Minneapolis whose Second Amendment rights were being restricted, in a decision by District Court Judge Catherine Menendez, she held that the 18 to 20-year-old restrictions on guns were unconstitutional under the Second Amendment, that 18 to 20-year-olds were entitled to Second Amendment rights like any other American. Now, in the context of that opinion, which I'll put a link to down below, there's a discussion of one of the experts proffered by the state of Minnesota, and specifically, there's a discussion of his argument, and you can see where they're going with this. His argument goes like this. This is what the judge wrote about the argument. Quote, the professor, who was the expert for the state, the professor, quote, testified that he was aware of no such laws, but deemed the inquiry a bad question. To understand the Second Amendment, the expert argued, one must, quote, this is key, folks, one must, quote, canvass a variety of historical topics, close quote. And the court continues, and not adopt a, quote, discredited tunnel vision approach to historical analysis, close quote. So you see how the expert in history proffered by the state of Minnesota is talking about how to understand the Second Amendment. You don't look to what the Supreme Court tells you to look to, which is the nation's historical tradition of specific firearm regulations. Instead, according to this expert by the government, you're supposed to understand the Second Amendment by canvassing a variety of historical topics, or perhaps not adopting a discredited tunnel vision approach to historical analysis. This is just an excuse, as I see it, to say, ignore what the Supreme Court says in terms of laser focusing on actual laws enacted at the time of the founding, and let's talk about these other ideas. Again, I like to use the metaphor. I like to stand on the riverbanks of history as history flows past me and drawing conclusions about trend lines and narratives and different concepts like this, these general, vague notions, which would, of course, if adopted, allow the courts to cherry pick the history they like to justify gun control laws. But the Supreme Court said, no, that's not what you're allowed to do. The only way the government can justify a modern-day gun control law is by showing specific laws justifying or showing the nation's historical tradition of firearm regulation. Now, I'm happy to report that Judge Menendez in Worth versus Harrington agreed with my view of Bruen, and this is what she wrote as she rejected the opinion of the state's expert to look at general history as opposed to very specific history of gun laws at the time. The judge writes, quote, while it could be sound, this is what she says, while it could be, quote, sound to consider the context the expert referenced, the court cannot discern how to incorporate that context into Bruen's mandated approach to analogical reasoning. Under Bruen, it is the law on the books that matter, not a historian's opinion about abstract social mores. Let me tell you the essence of what Judge Menendez said. She basically said, while it might be sound or interesting to consider what the state's expert said in terms of considering history, she said that there's no real way to incorporate that into the Bruen methodology of looking for specific laws on the books. So she basically says, hey, historians can have all sorts of opinions, but if the laws are not on the books at the time of the founding, I am not going to consider that other history because Nysurfer versus Bruen tells me I need to look at actual laws on the books in the context of historical traditions of firearm regulations, which again specifically means laws on the books. So to conclude, when we talk about text and history, which many people say is how you interpret the Second Amendment, I think we should start to be more precise. Specifically, what the Supreme Court said is you look to the text first. The text of the Second Amendment first, yes. But then the second step is not to look generically at history, because if we say generically history, we run the risk that the anti-gunners will try to exploit that generality to justify gun control regulations that there's no support for based on the proper way to interpret Bruen, which is this. First step is text. Second step is are there historical analog laws? So instead of text and history, it should be text and then historical analog laws enforceable on the books in the relevant time period. That is part two. Not generic history, but historical analogs on the books at the time enforceable. Okay, folks, hope you learned a little bit something here today. Hope this wasn't too geeky and laborious. And if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.